Hey, thank you for joining us. I'm Kelly Beeson. We are following breaking news out of the Supreme Court. A high court just blocked President Biden's student loan forgiveness plans. The decision means more than 40 million Americans are responsible to repay more than $430 billion in student loans. The collective student debt currently stands at $1.8 trillion. A source with the White House says President Biden has vowed to keep fighting to cancel student loan debt. And joining us now is Seth, Berenzweig, business and compliance attorney and Supreme Court expert, to dig in a little deeper. So there are many who say this move is a victory, having students take responsibility for the loans that they took out. But what's interesting is these are promises the president made repeatedly to students, and now we're seeing the forgiveness won't be moving forward. It impacts 40 million people, as you know, and it appears to really shine a light on the balance of constitutional power here.
That's exactly right. On the one hand, it is really a very broad, powerful decision because, as you accurately noted, it affects 40 million individuals in the United States and $400 billion. And that's really a very large scope. But it also has profound impacts because it is a fundamental shift in the constitutional balance of powers here in Washington. And it really cues into the deference or the lack of deference that the Supreme Court provides to administrative agencies. The agencies, of course, are a part of the executive branch. And there have been many decades of significant deference to agencies. I promise I won't get you lost in the legal weeds, but it was called the Chevron doctrine. Just last year, the Supreme Court stood by a doctrine known as the Major Questions Doctrine to overturn some EPA greenhouse emissions regulations. That came up again today. The Supreme Court rejected the administration's move as an overreach, stating that under this doctrine, since it had significant economic and political consequences, Congress had to speak to it directly and explicitly. And Justice Kagan had a blistering dissent, noting that this is a huge shift in the law. And she raises some interesting points. So this decision is not shocking in its result, but it has major implications, not only from a financial, but from a constitutional standpoint.
Certainly. So it sounds like borrowers will be resuming payments in the coming weeks. Will there be some unique challenges in a high interest environment? And how do you best recommend borrowers move forward here?
Yes. So hopefully borrowers used the standstill period of a couple of years during the pandemic to put cash away. And their best strategy would be to try to redeploy cash as a means to pay down the principal balance of their loans. Unfortunately, not only did the Supreme Court rule that students individually lack legal standing to challenge this, but now, of course, we're in an increasing interest rate environment, which will further increase the second half of this year. This is very trying for the students. They have very limited options other than to try to preserve cash and to start to pay down that balance because the interest rate environment is only going to get worse.
All right, important points to make. And as you know, Seth, the SCOTUS ruling for business owners also has some wide-ranging impacts here. So they are backing a website designer who did not want to make designs for gay couples. Now, you say in certain regions this could create a potential war zone in small business America. Many say this is a win for the rights of business owners. What is your thought process? What are your concerns moving forward?
This is a landmark shift in the law. Statutes such as the Colorado statute at issue provided that a provider of any goods and services could not discriminate and withhold services based upon a protected class. As Justice Sotomayor said in her dissent today, and I'm reading it off to the side here, today the court, for the first time in its history, grants a business open to the public a constitutional right to refuse service to members of a protected class. What has happened now is the Supreme Court has changed the legal standard from looking at it in terms of it being providing a good or a service to now creating a new legal flag that small businesses can carry to say that it violates their expressive rights. In this case, the small business owner of this digital web company and agency said that by creating the code and creating the language around that site that she was being forced to express supportive views relative to gay marriage. Frankly, that was not only a creative argument, but this is the first time the Supreme Court has elevated freedom of speech under the First Amendment as a tool in the toolbox for small businesses. And the reason why I believe this is going to create a tsunami of litigation in certain red states, perhaps, is because now companies that say that they create expressive content will use this as a new weapon to say that they don't want to do business with these customers. Now, on the one hand, other businesses will come in and pick up the slack and say, fine, bring the business to us. But this is going to create more conflict because there are new reasons for small businesses in America to say that they have a constitutional way to come after and refuse to provide these kinds of basic services to, for example, the LGBTQ or the community that have gay marriages. This was something that did not exist. This is a major shift in the law, and I would expect this to create new battlegrounds as we move forward in the business community.
In terms of the implications, Seth, do you believe lawsuits are coming?
Absolutely. I think that this is really a blueprint for new litigation coming down the pike. How do you draw the line between expressive content? So, for example, can an attorney say that he or she refuses to represent someone because they're in a gay marriage and they're exercising First Amendment freedom of expression? This is a new flag of a constitutional dimension that small businesses are going to be able to use. So I think that the two common denominators of the decisions today from the Supreme Court is that in the first case, you're going to have new litigation with regard to a new array of business regulations coming from Washington with those new challenges. And in the other business case, you'll have new small business litigation challenges to companies that are going to create and hold this new First Amendment constitutional flag, exercising what they claim to be a freedom of expression.
All right, Seth Berenzweig, thank you so much for joining us. We appreciate it.